Okay, so I do have a slide deck and I'd like to run through these, and I would encourage you to interrupt me because while I'm going through this, because with this platform, I can't always see your raised hands. So feel free to just, or Michelle, perhaps you can interrupt if you see a raised hand or a question in the chat. So we are going to go through where we are in the E-rate calendar and what activities are you are presented with to complete in the next month or so. So the first slide here, slide 2, goes through the funding years, and it reminds us that we actually have 3 active funding years, and right now we're in funding year 2024, which will be for the service period that begins July 1, 2024. We have a deadline of March 27th to file our Form 471s. That's the funding application. And so because you have a 28-day mandatory bidding period, your last day to post a 470 and comply with the 28-day waiting period and also meet the 471 deadline is February 28th, which is 13 days away. So here we are in the calendar. We've got our flow chart. And so we're doing 470, our bidding documents, where we ask for requests for quotes or bids. Then we're doing our bid evaluation, which we're going to talk about today. You have to sign your contract and do a contract record and file your 471 and get all of that done by March 27th. So here is just a reiteration of these dates, because I think seeing them frequently will help indelibly imprint them on your in your mind that February 28th is the last day to post your 470. And March 27th is our 471 deadline. And the reason these dates don't line up is that this year, being a presidential election year, is also a leap year. So we have 29 days in February. Okay, so we're going to go through 470 bidding, just some reminders. You've got to do a 470 if you have a new service or equipment purchase that you want to make, or you have an existing contract that is going to expire on or before June 30th, 2025, or you are purchasing Category 1 internet or data circuits on a month-to-month non-contract basis. So when a 470 is not required is, first, your state network circuits. The state applies for those circuits on your behalf. Second, if the contract is going to continually, is in effect still past 2025, because it has voluntary extensions. Or if you have commercially available business internet service where you don't have to bid at all. And that happens if you have 100 megs up or downstream and 10 megs upstream, and your total annual cost is $3,600 or less per year. Here are the reminders. So if you have to post a 470, you are allowed to include all of your requests for quotes on one form. I just got a question yesterday where a vendor was telling an applicant in our state that you weren't supposed to do it that way, and that the vendor thought, well, they have to bid on everything on the form or otherwise they're disqualified, and that simply is not accurate. You are allowed to put multiple service requests for both Category 1 and Category 2 on the same 470. If you find that the form does not give you enough space to describe what your requests are, then you can prepare a supplemental document, like in the form of a Word document, and upload that document when you prepare your 470. And generically, any of those uploaded documents are referred to as a request for proposal. It's only mandatory if you're doing dark fiber or buying your own fiber and installing it, or buying Category 1 equipment. And to my knowledge, no one in our state does that. Most of your circuits, if you're not on the state network, are going to be leased lit fiber. And when you update information on the 470, because you may receive questions from vendors or you have supplemental information you want to add, if you have uploaded that narrative document that we call a RFP, then you can update that and upload the supplemental information on your in your Epic portal. One important reminder that has become a new sort of trap, or what I call got you, is that although the bidding deadline is the minimum deadline is a 28-day waiting period, the program now says that if you don't specify a bid deadline in your 470, so in other words, you don't use the minimum deadline as the bid deadline, then you are required to accept bids and consider them up until the time you conduct your bid evaluation. So if you get a bid in after that 28-day waiting period expires and you have not yet evaluated the bids, then you are required to consider that bid as well. And that's only if you don't specify a bid deadline in your 470 when you describe your service request. So in the narrative text box, you're going to want to provide information about your service requests that will help the service providers prepare a responsive quote. And if you want a non-contract service or month-to-month service for Category 1, and you are required to also list your disqualification factors. So disqualification factor is a question that can be answered yes, no. And it is a mandatory requirement that the vendor meet in order to have their bid considered. One new thing that we've gotten clarification of just in recent weeks is if you require installation to be part of the equipment or service that you want to buy from a vendor, you are required to state that that is a mandatory requirement in your narrative on your 470. So if the vendor fails to provide the quote for the labor to install the equipment, then you don't want to consider that bid for the equipment. In other words, you want a turnkey solution from the same vendor. You're going to want to state that in your 470 so that if you receive an equipment only bid where you also wanted it installed, you would not even have to consider that bid because the bid was incomplete and it did not meet your minimum requirements. Just a reminder, the standard for bidding is open and fair so that all service providers have the same access to the information so that they don't feel that they're not being treated properly, and that the program administrator in evaluating and looking at how you did your bidding, you want to make sure that you can demonstrate that it was fair, open, that you considered all legitimate bids so that you don't get your a funding denial or receive funding approval and then later have it rescinded or have to pay it back. So here's where we need to be mindful of the importance of fairness in treating the vendors fairly, because a disgruntled bidder can drop a dime and conduct a whistleblower complaint or register a whistleblower complaint. They can do it anonymously, and the program administrator is duty bound to investigate all such accusations, which means that your 471 application is going to be subject to an intensified scrutiny, and it could result in a delay in its processing and approval, and payments, reimbursements on that year's application or prior year applications could be suspended indefinitely while the whistleblower complaint is being investigated. So all of these are good reasons why to treat the vendors fairly and show them that you are being open and honest with all of them. They do have the right and ability to reach out to you to ask questions to clarify the scope of the equipment or services that you're requesting bids on. You are required and ensure that you indicate to them and signal to them that you will consider all bids that meet the minimum bid requirements. And we do have a problem that has gotten worse each year in the program. We have certain vendors that basically use a robot to capture all of the new 470s that are posted each day and will generate like an auto bid that is the vendor's like standard marketing information that may or may not contain prices. It may or may not comply with your minimum bid requirements. And in the past, we were told that you could just simply set those aside and don't even have to evaluate them as a legitimate bid. And now the FCC is saying, no, if you receive one of these auto bids, you are required to examine it. If it does meet your minimum bid processing, your minimum bid requirements, then you are duty bound to examine and evaluate that bid. But if it fails to meet your minimum bid requirements, then you would record the disqualification reasons, and you could then set aside that bid and not evaluate it on its merits. But the big thing here is now that spam or auto bid now becomes part of the burden of your document retention requirements. So if you have questions about whether you've conducted an open and fair bidding, because you do have 13 additional days to get your 470 posted, the easiest thing to do is to start over and get your 470 posted again, cancel the old one, and notify any vendors that may have bid on the old one that you are conducting the new procurement, the new 470. So before I go on, does anyone have questions about posting their 470? Okay, hearing no questions, and I don't see any in the chat, I'm going to keep going. And now we're going to get into the bid evaluation. So we've now done our 470. We've now waited the 28 days. So you're on the 29th day and you can start your bid evaluation. And what we need to do here is you have to rely, you can rely on the deadline you put in the 470. You are allowed to make that deadline as early as the expiration of the 28-day waiting period, or you can make it a longer deadline that you specify in your 470. Whatever the deadline was that you identified, you would need to comply with that deadline. Then what you need to do is the applicant, even if an applicant retains the services of a professional consultant to assist with their E-rate filings, it is still the applicant's responsibility to perform the bid evaluation and to make the final decision to select the winning bidder. You can receive guidance and advice and assistance from the consultant, but it ultimately must be the applicant's decision and responsibility. So what the applicant can do with the assistance of the consultant is you're going to first want to review the proposals you've received to make sure that they've all complied with the minimum bid requirements. So these would be any of the factors you listed in your 470 as grounds for disqualification. If they didn't meet those requirements, then the bid could be disqualified. You are going to want to keep a record for any bids that you do disqualify and the reasons. And then last, just to reiterate, if there was no deadline specified in your 470, then you are obligated to accept bids and review any bid that you received up until the time that you do conduct your bid evaluation. Okay, Christy asks, and this is a great question. A bidder requested I send them the award matrix of the bid submitted so they could provide an improved response. I did not. Do I have to? And the answer is no. First off, after you've done your bid evaluation, it would actually be very unfair to all the other bidders if you allowed that one bidder to submit an improved response, number one. Number two, how could it be open and fair to those other bidders if the one bidder now has access to all of the information that you relied on, including price information, to conduct your bid evaluation? And thirdly, our state has an open records law. I believe that you can require the vendor to go through the open records request, and then depending on what the statute and your legal counsel says, whether that bid evaluation matrix must be made public. And even if it is required to be made public, you may have reason to not disclose the prices, even in response to that open records request. So absolutely, you're not required for E-rate purposes to disclose the bid evaluation. You are required to share that with the E-rate administrator if they ask for it. And again, whether or not you have to disclose that to a bidder is a matter of state law under the open records law. Christy, did that answer your question? And I hope it reassured you that you did the right thing there, and you did. Okay, so the cardinal standard for bid evaluation is cost effectiveness, which means that you are allowed to take factors into account in addition to the price, but the price of the E-rate eligible costs for either the equipment or service has to have the category with the most possible number of points compared to any other category. So you are allowed to have other factors that are not cost-based and are qualitative-based, as long as no one single other factor besides the price of E-rate eligible services and equipment is weighted more heavily. So even in the situation where you may have a piece of equipment or a service where part of it is eligible for E-rate and part is not, and you are allowed to score the ineligible costs of a solution separate from the eligible costs of the solution, but the ineligible costs must not have as many points, maximum number of points available as the E-rate eligible costs factor. So other examples, and this is not exhaustive, is what kinds of things might you want to take into account? Well, prior experience, the personnel qualifications of the vendor, their management capability, how deep is their bench, to provide the service or equipment that you've asked for, whether the technical solution meets your needs, and again, the ineligible costs. There are no hard and fast rules as to what factors you want or may consider, but they do have to have some bearing on the procurement. So a common factor that I have seen and discussed with many applicants is that you may want to have a requirement that the vendor has a business office located within a certain mile radius of your school district or library area, so that the vendor can be available to provide support or maintain or help with the configuration of the equipment even if you are going to do that without the using your E-rate funding for labor or support. So that is just another example. And you have 4 different scenarios that require you to document how you came up with your vendor choice. The first one is you have an existing service and you didn't receive any new proposals. And the second is that you have a new service or equipment and you didn't receive proposals. The third is that you have at least one proposal. And the fourth scenario is you have more than one, 2 or more proposals. So in scenario 1, all you have to do is verify that the vendor you currently receive service from will continue to provide the service. You can use an existing bill as the basis of identifying the costs of that service, or if you can ask the vendor if they anticipate making a price increase in the upcoming year, and then just get a documentation from the vendor of that price increase. What's important here is that you simply document through sending yourself an email or a memo to the file that this was how you arrived at your decision to continue using this one vendor that you list on your application. That's important because you've got a 10-year documentation requirement, and that means that the E-rate program can come and audit your records for that 10-year period. If you're not in the same role you currently are in, and you move on, you resign, you retire, etc., you're going to want to make sure that this documentation is in your file so that whoever is the point person for the audit would have that information available to document your decision. And if the vendor is going to go out of business or they're not going to offer the service you need, then you're going to go on to the next scenario, which you're going to treat it as that you didn't receive a bid. And the answer here is to go out and actively solicit 1 or more bids from an E-rate vendor that can provide the service or equipment. And what you then do is, if you have the one bid, you go through the exercise again of making sure that the proposal is reasonably priced and therefore cost effective. So in other words, you can't just assume that because you have one bid, you automatically get to choose that bid. You still have an obligation through internet research or other, online research to determine that the price that's being quoted is within the range of reasonableness. And all you have to do then is save the screenshot or PDF, the internet pages that you and sites that you visited to show that the price of the bid was within the price, a reasonable range of prices that you saw online. If it turns out that that one bid is excessive and is way beyond the cost that you see from looking at Amazon, looking at eBay, looking at, vendor sites, then you still would go out and solicit another bid until you find a bid that is reasonably priced. So then if you have more than one bid, so 2 or more, then you do have to do a formal bid evaluation matrix. Up until now, all you've had to do is either screenshot or PDF your research documents to show that the price is reasonable, send yourself an email or a memo to the file that says, this is how you came to make this vendor selection because you either didn't receive a bid or you had one bid and you decided that this bid was, reasonable, and here's why. For 2 or more bids, this is when you do have to go through a formal bid evaluation. And you do have to ensure that the bids you're reviewing are for apples to apples comparison. And Christy, I know you sent me an email about this quite some time ago, and I don't think I responded to it. And to ensure that we're being very clear here, if you ask for a bid to address whatever service or equipment you think you need to meet your needs, and vendors propose different manufacturers or different quantities, then you are allowed to communicate with the vendor before conducting the bid evaluation to say, ask them, how did you decide on these quantities? To ask the vendor questions to make sure that this vendor, even though the quantities that they quoted are different from a different vendor's quantities, that both of the bids are intended to respond to meet your needs. And that would be one way to ensure that you're comparing like bids. The other way to do it is to basically take the look at the bids and extract the price per unit and then compare the price for the same number of units, like for access points as an example. So you are allowed to, again, take the information from the vendor's bid and make sure that when you're looking at the price for the E-rate eligible costs of equipment or service, that you are looking at an apples to apples comparison. You can even go so far as to ask the vendor if they bid and you think that the quantities were too much, you can ask them to submit a revised bid with lower quantities. You are, again, allowed, after you have started your bid evaluation, if you feel that the information that you have, you're unable to really do an evaluation on apples to apples prices, then you are permitted to go back out to the vendors, ask them questions to make sure you understand their bids and you know how to do the evaluation. The other thing that I wanted to mention is that if you bid different equipment, different kinds of equipment. So an example, you bid power over Ethernet switches, and you also bid access points. There's nothing that mandates that you make an award to the same vendor for those switches and those access points. You are permitted to make an award for some or of the equipment to one vendor and some to another vendor. This may be particularly beneficial when your staff or you are going to be responsible for the installation configuration. If you are going to be using your E-rate funding to have the vendor perform the labor to do the installation configuration, then it may make more sense to do a turnkey solution and have an award made to a single vendor. Again, you have lots of flexibility. You just need to document what your process is. The biggest challenge that you may experience when examining and reviewing Category 2 equipment bids is you may have specified your preferred manufacturer, but E-rate does require that you receive and evaluate bids from other manufacturers other than your preferred manufacturer. So what you're going to want to do there is you're going to want to look at the documentation. So did you require that bids for alternative manufacturers that they have to submit the specification sheets for the equipment to demonstrate that the equipment they're bidding on is truly comparable to the functions and features of your preferred manufacturer's equipment? If you required that as a minimum bid requirement and they failed to submit that documentation, then you are not obligated to then proceed to review the bid and the substance of the bid because that vendor failed to comply with your minimum bid requirements because they failed to submit the required spec sheets. The other, so if a vendor did comply with with the requirement and they did submit the spec sheets, then it is up to you to then examine your equipment specs and the other the alternative equipment manufacturer specs to see if the equipment truly is comparable. You are also allowed to require that the alternative manufacturer's equipment has to be interoperable with your existing network equipment. If it has to be, if the new equipment does have to be integrated into your network. So, for example, if you have access points that you're going to continue to use, that and you're bidding new access points, and the new access points you want to make sure can work with the existing access points and the same way in which you manage and configure the access points. You can say that the new access points have to be interoperable with the existing equipment. You can, the key here is to document your review and reasons for either accepting and agreeing that the bid is truly comparable, or and is technically would meet your requirements, or the bid would not meet your technical requirements. So this would be a situation where you likely would want to have a bid evaluation factor for technical solution. Again, going back to the factors other than cost, you could use the technical solution category to then evaluate and determine whether the alternative manufacturer bid really does meet your needs and you feel like that technical solution would work for you. Again, all the key here is to explain how you arrived at your selection. You know, what were your factors? What were the points available in each factor? And how did you come to decide to score each factor for each bid? So here's a sample evaluation where you would look at the different factors. And again, none of these are etched in stone or required, other than the fact that the price of E-rate eligible products and services, the maximum number of points there is greater than any other category. So before we move on, questions about bid evaluation, and I see some. Okay. Christy says, okay, what about the case for switch license renewals, but the vendor bids with different switches? Dan, great question. In this situation, I think you would, if you're looking for renewal licenses, right? The operating, software or guts to, and you don't want to buy new equipment or new switches. And the vendor says, okay, I'm going to bid the licenses and I'm also going to bid the new switches. Well, first of all, those switches weren't listed. You indicated in your narrative, I hope, on your 470 that you were just looking for licenses. And then second, in this situation, because you are not bidding those switches and you don't need to buy those switches, I would consider all of those costs of buying the new switches as an ineligible cost. So you would mark down the vendor's bid that has the license with the new switches. And I would mark it down. You can mark it down for technical solution. You could mark it down for the price of ineligible equipment, because now you have to buy all these new switches to go with the license, right? Or you could, depending on how you configured your 470, if you had said that these licenses have to be interoperable and you specified the particular manufacturer switches, then if the license that has been bid isn't a license that would work with your existing switches, then I think you could disqualify the bid altogether. Dan, does that answer your questions? And do you want to unmute if you want to talk about this some more? Okay, let's see what Dan said. Nope, that answers it. Good. Okay, Christy, I'm going to read yours out loud. These are great questions about bidding. 3 vendors didn't tell me how many access points I needed. They told me, here are the models and the prices. Now you pick from this information what you think you need. Only 1 vendor told me exactly what they felt would be best to fix my network. So I used their numbers and took all the other 3 vendors' info and made their numbers match the better bid to compare apples to apples. And then I made the admin team go through the information without being aware of my choice. Chrissy, that is a great best practice. You only have the 1 vendor that gave you a recommendation of the quantity of access points you needed. You relied on the best available information. You then took that quantity and you used that quantity to calculate the unit price of the other vendor's access points. So then you were looking at the same quantity of access points times the different vendors' unit costs to arrive at the price. And then you blindly asked your other staff to look at the technical feasibility of the solution. So they did the technical solution evaluation without even being influenced by the price. That's outstanding. And I think then as long as the 2, you were able to take the 2 scores and combine them, then I think you likely came out with the best solution for your district. And all you would have to do is this narrative right here in this question would just become part of your bid evaluation documentation. Okay. One other note that I just wanted to mention as we talk about the price issue. You can take whatever the maximum number of price points are, and you can decide, okay, the lowest bid gets the maximum number of points, and if I have 3 other bids, you can basically decide each higher cost bid in sequence would get marked down a certain number of points. Absolutely fine to do. Or you could be a little bit more mathematically precise about it, which is how many of like state level procurements operate, where you do a formula and you basically look at the lowest price bid gets the maximum number of points. They get 100% of those points because they're low bid. Then what you do is you take the low bid as the numerator, and the denominator to calculate a percentage is the price of the bid being evaluated. That's going to show the percentage relationship between the low bid and the next low bid. You take that percentage and you multiply that percentage by the maximum number of points to arrive at that vendor's price points, and so on. The difference in the approach is that in the percentage approach that I described, if the next highest price vendor is only a little bit more expensive than the lowest bid, they're going to get a relatively higher portion of those points than they would have received using the other methodology, where it's basically a straight line reduction in the number of points based on where that vendor's bid stacks up along the other vendor's bids. E-rate does not require this, I assure you. So if you have used that other methodology, do not change it. If you have yet to do your bid evaluation, then this is being offered as a suggestion, recommendation, but again, not required by E-rate. Okay, any questions about bid evaluation? Reminders, the applicant must do it. You can ask your consultant for assistance, guidance, but it is up to the applicant to make the choices and make the ultimate decision. So once you've done that, then the next step is to memorialize your decision and actually sign an agreement with a vendor. And so now what you've done is your bid evaluation, and now it's time that the applicant at least has to sign an agreement before you can finalize your 471. So category 1, a contract is required if it's not a month-to-month service, or you have amended an existing multi-year contract to either extend it or to increase the quantity or bandwidth that you're purchasing, and that these changes are allowed and considered within the original scope of your original contract. Okay? So C2, it's very easy. All service and equipment requests for category 2 have to be under contract. So you have to have posted a 470 for these service requests. And the only time you would be excused from that requirement is if you had a maintenance service agreement or a managed internal broadband service agreement, and it was for multiple years. It's highly unlikely. I've not seen many, if any, in the state handled as multi-year agreements. So here's your timing, right? So you have to sign the contract after you do the bid evaluation, which means you had to wait your 28 days. But you then have to have the applicant sign and date the contract before you can create a contract record in Epic and then file your 471. So here are some planning considerations to take into account. Are you going to provide the contract draft, or are you going to ask the vendor for a price quote that you can simply sign? And 9 times out of 10, that's what you're going to do. If the vendor says, I don't have an agreement, then you can come up with a sample or a one-page agreement. And I do have some samples that I've provided upon request. In your school, are you authorized to sign a contract? Or does it have to be signed by a different official? And if in either case, do you need school board approval before you enter and sign an agreement? If any of these considerations have to be met, then you need to take the timing of your school board meeting and the internal review process into account when you're planning your steps to getting your 471 filed. Do you have an attorney, a school board solicitor that has to sign off on agreements? You know, these are the internal steps to take into consideration. And one of the reasons why you don't want to wait until that very last day to post the 470, because you would have to get all of these things done all in the same day and meet the 471 filing deadline. Okay. And let's see, question. I do not need board approval, but I do attach a signed PO with the contract to the vendor. That's great, Christy. And again, that's going to be your local board policies and what's required. And the PO, generally, you're going to want, for equipment purchase, you're going to want to make sure that the equipment is not delivered to your site, to your district before April 1. Because April 1 is what's required, is the earliest date. April 1, 2024 is the earliest date that you can have that equipment delivered or installed for the upcoming funding year. Okay, so step by step, you've done your bid evaluation. Do you need anybody internally to sign off on that, or do you have the authority to conduct that bid evaluation? And then you're going to want to notify the winning and losing bidders. You can do that through email. And if you want the winning bidder to submit the contract or the price quote, you can ask them to do so. And keep in mind that if you decide to purchase some but not all of the equipment in the original quote, you can ask the vendor to revise the quote to reflect only the equipment and service that you intend to purchase from them. Detail, but here are the minimum requirements. You need basically the vendor's name, their SPIN. Oh, my internet is unstable. Can you hear me okay?
Yeah, I can hear you just fine.
Okay. So you need to make sure you've got the vendor name, the quantities, the service, the contract dates. And here's for those of you who are off the state network and you have building to building circuits, these are some other considerations you want to include. I'm going to gloss over this. And then C2 equipment contracts. This is really important. You want the contract date to be April 1, 2024 through September 30, 2025, because you've got an extra 3 months before the funding year starts and an extra 3 months at the end of the funding year to purchase and install the equipment. Make sure any contract you're signing has services and equipment that were on your 470. So if you are going to sign a managed internal broadband service contract, make sure that you bid that category on your 470. Here, I think I mentioned, the taxes and surcharges, any shipping charges. If you need discounted bills, if that is a requirement for your school or library, specify that. And remember that the signature of the applicant is required before you file your 471. The service provider signature is not mandatory, but it's certainly a best practice to make sure that they are bound to the contract. If you don't want to proceed with the purchase unless you get your E-rate funding approval, then you can include language, a contingency language similar to the language that I have on page 36 of the slide deck. So this would basically say you're not going to proceed with the purchase unless you get E-rate funding approval or you waive that contingency. For maintenance and MIPS contracts, you're going to want to make sure that those contracts run July 1 through June 30 because you only have the 12-month period available for them. You do not get the extra 3 months on either end. And you're going to want to make sure that all of the equipment that is being serviced is listed. And you want to make sure that the scope of services do not exceed what's eligible for E-rate, which is repair and upkeep, wire and cable maintenance, configuration changes, basic technical support, such as online telephone-based technical support, software upgrades and patches. You do not want to have equipment, and here's MIBS, what's allowed. You do not want to have help desk language listed, end user equipment maintenance, any equipment that's not eligible for E-rate, you don't want to have included in the scope of this agreement. Otherwise, you're going to have a partial disallowance, and you would then be responsible for having to pay those charges in full to the vendor. The contract award date is required to be entered into your contract record in Epic, and that's going to be the date that the school or library official signed the agreement. Okay, contract record. I'm not going to go through this in detail because we have a separate guide in the resource manual that I'll send out in the listserv message that includes these slide decks. And that's where you have to create the contract record. And the important thing here is that if you have an extension of an existing contract, you do not create a new record. You only create a new record when you have a new agreement.
Deborah, you
And,
do have a new question in
oh,
chat.
okay, let's see. Let's get it. One vendor misquoted a Switch license for the wrong version of the Switch. The 28 days has passed. Can they still resubmit, or is their quote disqualified because they submitted for the wrong Switch license type? Here's a question, Dan. Did you have other bids that you could rely on? Do you want to give this vendor an opportunity to resubmit? What I would say is you are not required to, but you can allow them to. That's what I would say. Okay. And creating the contract record, you're going to do that over here in Epic. You're going to go to manage contracts, and that's where you're going to add a new contract. Okay. 471 guide, I'm still working on, but here's after you do the contract signing and you do the contract record is where you're going to file your 471. Here's what you need to remember. You are going to need to know the price for each component. You're going to have to separately itemize that. You're going to need to know the contract record to associate with the funding request. And you're going to need to know the quantities per unit for your equipment. When it comes time to file your 471s, the cardinal rule here is you cannot mix category 1 and category 2. They must be filed on separate applications. And you would file a separate funding request, not necessarily a separate application, for each separate contract that you have with a vendor and for each separate subcategory under category 2. So you've got 3 subcategories. You've got internal connections, that's equipment. You've got maintenance, and you've got the managed internal broadband service. So you may have one contract that covers both maintenance and equipment, but you would need to file 2 separate funding requests, one for maintenance and one for equipment. Okay? And I think I just go ahead.
There is another question.
Yeah. Under SC, are you required to disclose? You know what, Alexander, I would I'm not comfortable telling you the answer because I'm not sure. And I think it is a matter to talk to your business manager to get their reaction and talk to your school district solicitor. I think this is a question under open records, you know, a form, and you can require them to do a formal request, but E-rate does not require this information to be disclosed. Okay, good. So I'm working on the guide right now. I'm about halfway through the category 1, then I'll update the category 2 guide. But you do have the guides from last year, you know, for funding year 2023 in your resource manual that I handed out. And those will be updated and sent to you. The only thing that's really going to be different this year is if anybody is applying for school bus Wi-Fi equipment or service, then the category 1 guide is being updated to include one of those FRNs as an example. So now this has been great that you've been sending me your questions throughout the discussion, but I'd like to now turn off the recording. I'm going to stop sharing and I'm going to turn off the recording and see if you have any other questions that you would like